Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. On 16th July, Trial Panel 1 pronounced the trial judgment in the Pieter Schala case. This is the second trial judgment at the Specialist Chambers involving war crimes. The trial panel found Mr. Schala guilty of the war crimes of arbitrary detention, torture, and murder, and sentenced him to a prison sentence of 18 years with credit for the time served. For legal reasons, the panel acquitted Mr. Schala for the crime of cruel treatment. The panel highlighted that it conducted this trial against the backdrop of a persistent climate of witness intimidation, which had a visible impact on the evidence provided by some of the witnesses who appeared before the panel. Both parties can appeal the judgment by filing a notice of appeal within 30 days on the grounds of an alleged error of law, an error of facts, or an error in sentencing. On 11th July, the trial panel had decided on reducing reductions of the closing statements in this case and instructed the registry accordingly. This was the 7th decision on reducing reductions in this case and is part of the trial panel's effort to make the proceedings as transparent as possible. On 12th July, Sabit Janouzi and Ismet Bakhtiari pleaded not guilty on the occasion of their further appearance. The public hearing followed the confirmation of the amended indictment by the pretrial judge. The amended indictment included an additional charge against Mr. Janouzi and Mr. Bakhtiari, which made their further appearance necessary. In view of the new charge, and due to the Janouzi defense's stated intention to file a preliminary motion related to it, the pretrial judge on 12th July issued a decision in which she vacated her previous deadline for the defense to file their pretrial brief on 15th July and ordered the Janouzi defense to file its request for an extension of the deadline by 15th July. In addition, she instructed the defense of Mr. Bakhtiari and Mr. Schala to file their responses no later than Tuesday, 16th July. Lastly, the pretrial judge vacated the previously set date for handing over the case file to a trial panel and informed the parties that a new date will be set in due course. In the same case, President Trandafilova on 16th July assigned a Supreme Court panel to decide on Mr. Haji Shala's request for protection of legality against the pretrial judge's decision on his continued detention. On 17th July, the Supreme Court panel ordered the SPO to respond to Mr. Shala's request, if it wishes to do so, by no later than Monday, 5th August 2024, and the defense to file its reply to the SPO's response latest by Monday, 19th August 2024. The panel consists of the judges Ekaterina Trandafilova, Christine van den Wijngaard, and Daniel Franzen. In the same case, the pretrial judge on 17th July rejected a request by the Schala defense to reconsider her decision on Mr. Schla's continued detention based on the fact that the deadline for handing over the case file to a trial panel was not yet set. The defense argued that given the delay in transferring the case to a trial panel, the time Mr. Schala may have to spend in detention would be unreasonable. The pretrial judge found that the Schala defense failed to demonstrate an error of reasoning in her previous decision and pointed out that any delays in regards to the handing over of the case file to a trial panel occurred to accommodate requests made by the defense. On 15th July, Trial Panel 2 ordered the continued detention of Jakub Krasniqi and Recep Selimi. In regards to both accused, the panel found that the risk that they may obstruct the progress of proceedings or commit further crimes continue to exist, especially considering the stage of the proceedings during which the names and personal details of certain highly sensitive witnesses have been and will continue to be disclosed. In this context, the panel found that the release of an accused with sensitive information in his possession would not be conducive to the effective protection of witnesses who are yet to testify. In case of Mr. Selimi, the panel also recalled its finding that it appears that Mr. Selimi has previously disclosed privileged information to unauthorized third parties. The panel concluded that it is only through the communication monitoring framework at the specialist chambers detention facilities that the risks can sufficiently be mitigated. On this background, the panel also rejected Mr. Krasniqi's request for conditional release during the court recess. Throughout the week, witness Bislim Zirapi continued his testimony in this case. The next hearing in the Thaci et al. Case is scheduled after the court recess on 19th August, starting at 9 in the morning. That is all from me. If there are any questions, I'll be happy to respond.